can try to do something by today, but I'm not sure.
You can try what?
I can try to do something today, but I'm not sure.
S&C Holdings versus Trayvon Steins.
Good afternoon, Your Honor. Tracy Thomas, speaking on behalf of the plaintiff.
Right. Trayvon Steins, they are not present. How would you like to proceed?
Your Honor, Mr. Steins has paid in full according to my client, and I just emailed Ms. Weidling a dismissal on this file.
Okay. Very good. I'll take that. Case is dismissed. That's without prejudice. We'll sign that and everything. Thank you, sir.
Thank you.
Calls the case of S&C Holdings versus Andre Harris.
Ready, Your Honor?
Andre Harris, they are not present. How would you like to proceed?
Your Honor, we do have personal service. I'm wondering if I can take a default judgment and a money judgment.
All right. You indeed do have personal service. Raise your right hand. Solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God.
I do.
Go ahead.
Your Honor, rent and fees to date to retain possession would be $2,479, and we would ask for a judgment in that amount.
Judgment to the plaintiff. That is by default for possession. Redemption amount in any amount requested with the writ to issue in 10 days. And
Thank
I'll
you,
sign
Honor.
that judgment upon presentation. Thank you.
I will present it this afternoon. Thank you, Your Honor. Have a good day.
You do the same. Willow Ridge Apartments versus Kiana Williams. That matter is dismissed on plaintiff's motion without prejudice.
Thank you, Your Honor. Have a good weekend.
Oh, I'm sorry, sir. I didn't know
It's
you were behind something else on my screen.
Oh,
All right.
no problem. It's great to talk to a local celebrity.
Yeah, okay. Well, I guess you're welcome. All
All right. Have a good
thanks.
weekend. Thank you.
Take care. You too. Sycamore Meadows versus Denicia McGuire.
Good afternoon, Your Honor. Carrie Zanin, P67390 on behalf of plaintiff.
I believe Miss McGuire is here. Hello.
Hello,
State your name.
Denasia McGuire.
All right. And where are we on this case?
You know, Judge, I got an email from SOS yesterday asking for the documentations again, the lease, the ledger, and the W-9 form. I did send an email to her as well this morning, but I have not received a response back. I do remember that Miss McGuire was supposed to pay towards the balance because I believe her portion was going to be $2,500 and she was to pay, and I don't have confirmation that she's paid that. So I guess I would turn the mic over to her.
I just got paid this morning. I was gonna let you guys know that when I got off work, I would go making a $600 payment today. That's all I could get.
That's all you could get?
Yeah, at the moment.
Okay.
With my job, I only get paid twice a month.
Right. But we're saying, how much is owing?
$5,109. Court cost of $175.
$5,109.
Yes, Judge. Court cost of $175 for a total of $5,284, Your Honor.
All right. Ms. McGuire, is Amy here? No. How much was SOS going to give you?
When I talked to, I believe her name was Amy, she said it was three that they were.
3,000? Okay, so are you subsidized?
Yes.
Okay, that's why. Okay, so so there's a 3,000. What's your monthly rent?
468.
Okay. So here's going to be our problem. So let's see, you were on the 17th. So on the 21st and the 31st, on the 24th, did you pay 1,000?
I wasn't able to.
Oh, boy. And on the 30, and today you don't have the 1,000, you only have 6.
6 of it, yes. And I
Oh.
won't be able to drop that off until I get off of work.
So, Mr. Dwyer, here's gonna be the problem. If I'm at 52.84, basically 5,300, right? And you're gonna get the 3,000, but they're not gonna pay the 3,000 until you come up with the other 23.
Correct.
And then on top of that, I then have, you said 468, so I got about another 470 that I've got to tack on to that.
Correct. All right.
Judge, I don't mean to interrupt. I think the numbers I gave you are incorrect. I actually think that it's $5,613. I think the number I gave you was before May's rent. So I do apologize for that. It's actually 5,613.
Okay.
Sorry,
All right.
Judge.
No, it's okay. Ms. McGuire. Ms. McGuire, my problem is I don't know how mathematically this is even going to work. I mean, what do you, tell me what you see. I mean, how do you see yourself getting out of this? I mean, I don't believe, let me just say this. I think when you gave me the numbers on the 17th, I don't think you were trying to not tell me the truth. I mean, I think you thought you could do it. And it's not happening. So tell me what you think.
And try to do something by today, but I'm not sure.
You can try what?
I can try to do something today, but I'm not sure.
What? You all right? All right. When you tell me that, what do you mean you're going to try to do something? What are you?
I'll try to see if I can get some more money by today.
You don't get paid next until mid-June, right?
Yes.
And on that check, you're not going to, what's going to happen with that? I mean, how much is that check going to be?
I'm not sure. My checks are different.
Okay. Mr. Dwyer, regrettably, I think we've kind of come to the end of the road because I don't know how to make it work. What worries me is that, we have 3,000 sitting out there, but I got to get that other now to really 2,600. And I don't know where it's going to come from. Even if you pay the 600 you have today, then I'm at 2,000. But then tomorrow 470 clicks in.
So I go back up.
And so we've only really knocked off 130. So your next check though is the 14th,
15th.
15th.
Yes.
So you get paid the 15th and the 30th, is that?
Yeah, and if the month has a 31st, I get paid the 31st.
Okay. Hey, Mr. McGuire, I don't have a choice in this thing. Okay. I mean, we kind of worked it through. Do you also, did you also have 400 from DHS?
Yes,
So that's waiting out there too.
yes.
So I really have effectively 3,400 of this amount waiting. It's just, I mean, it's the same thing, but there's. Amy, I'm glad you showed up. You probably can't give us an answer. Is there, but even if she has the funding, I believe she's supposed to get 3,000.
Yes, Your Honor. So 3,000 from SOS. However, there's a portion that needs to be taken care of for their comfortable releasing. And then the part that I don't have more information about is what that arrangement is or.
All right. The court's going to find that there's no tribal issue. The court's going to enter a judgment for possession. The total redemption amount, the 5,613 was inclusive of cost, Ms. Zana.
It was not. 175 is due in cost, so $5,788.
$5,788. Okay, Ms. McGuire. I won't have the writ would normally issue the 10th.
I was thinking the 14th, Judge.
And I'm gonna go to the 17th, and the only reason is that a check for her comes the 15th.
Sounds good, Judge. Understand.
So a writ would issue June 17th. All right, so now, Ms. McGuire, I added some time onto that.
Thank you.
You're welcome. You have to make a decision of paying the 600 to the landlord, but yeah, I'm not going to tell you what to do, but you've got to come up with, really, it's effectively 27 with the cost of almost $2,800.
Correct.
So if you've got 6, you're going to need an additional 22 somehow or another.
Okay.
I've given you additional time. The only other option, and I don't know whether or not and can't promise you anything, the landlord's willing to work with you and set up a payment plan that I think would suffice. Is that correct, Amy?
Payment plan would be helpful. There was a payment plan and a COD that would be even more helpful.
Even more help. So it's a conditional order of dismissal, meaning that the case would be dismissed if there's a payment plan set up. I don't know how Sycamore Meadows is going to feel about that. I'm not going to get involved in that. If they want to convert this to a COD, I'm not going to have a problem with it.
Okay.
So that can happen, and Ms. Zanin would know how that would work if you work it out with your landlord. But I suggest that you get to them as soon as possible.
Right.
Try to see if there's a way that can work it out so you can certainly access at least 3,000 of those funds to maintain your housing.
Okay, correct. I can try to go I can try to leave work early today and see if I can go. Stay close when I get off work.
Okay, and is your voucher a site-based voucher, or?
I'm not sure.
You know, Ms. Zanin, whether she's it's not, you don't have a housing choice voucher, do you?
No.
Where you can move. I mean, your rent is subsidized through Sycamore,
Yes.
basically, right? All right. Well, you don't lose that, Ms. McGuire. Okay,
Okay, thank you.
do your best. And Ms. McGuire, I have to say, I hate doing this. You know that, right? And whenever you come in here, despite how bad things were going, I have to appreciate one thing about you. And that is you always had a smile on your face and hope in your heart. I could tell. All right. So we'll just hope for you.
Thank
Okay, Ms. McGuire, you take care of yourself.
Thank you, you too.
Kirk Glasso versus Artie Dracos.
Good afternoon, Your Honor. Jay McCurgy appearing on behalf of the plaintiff.
Oh, this is Gata. Dari.
Your name again, ma'am?
Gata Dari.
Yes, and for whatever reason, I skipped your name, but you're also on this case. All right. All right, folks, this is the second hearing. Did we get the money judgment corrected?
I believe so, Your Honor.
And again, counsel, I apologize for that. It made no sense to me, but yes, we do. We're good. Okay. So where are we now in this case?
Your Honor, last time we met, Miss Dari was stating her case as to why she didn't believe she should be on this money judgment. I'm here with Mr. Glassel, and we have reasons as to why we should. If the other parties are not available, we ask for a
Can take a
judgment.
default as to them. Ma'am,
Yes, sir.
you
Yes, Your
never
Honor.
moved in. Is that correct?
Correct. So due to personal reasons, I did not move in, family health issues. So I reviewed the document or the rental agreement. It says the lease agreement did not stipulate any notice requirement. And so if I had the intent of vacating, or as far as I know, again, a layperson, I go as far as what I read. So when I made the decision not to move in, that was due to a personal reason. So I never actually, within 2 weeks of actually signing the lease agreement, I decided to make that decision.
Ma'am, but you signed the rental agreement, correct?
Correct. With the intention of moving in.
Understood.
Mhm.
The very fact that you didn't move in, you're still liable under the agreement.
You're right. As far as I understood regarding what was served to me, it was regarding a holdover, which I wasn't aware of any holdover, what was going on with them. I had to reach out to the real estate agent that found the location for me to understand what was actually going on.
Right,
And-
that's right.
and that was-
The
yeah.
holdover. So, counsel, is
And-
all of the rent owing after the lease, after the lease had expired?
Correct, Your Honor. The lease, oh,
No, the last time they made a payment was February, I believe.
February, Your Honor, was the last payment we have.
And then the lease, I think, expired March 31st. So I'll talk to Sophia. She informed me that everything was up to date in regards to the actual rent. So it was 1 month.
Your Honor,
Go
Your
ahead,
Honor,
I'm sorry.
if I may clarify, or if I may add some light as to our position, it would be
Certainly.
the parties were both represented by a realtor. Miss Dari and Mr. and Mrs. Dracos applied together. If my client had thought Miss Dari was not going to move in and be a guarantor, we would have signed a guarantor agreement. It was Miss Dari's income that was used to approve the lease or approve the ability to move in. We were never notified that she wasn't in the location. We were never notified that she moved out, which I guess she says she didn't move in. She corresponded with the landlord as if she was a tenant.
I was coordinating because there was communicate.
Hold on a
Right.
second. But counsel, does the leasing provision doesn't doesn't require her to say anything prior to the termination of that lease.
Require her to say anything as far as her moving in or
Well,
not.
meaning, let's assume that all of the parties just vacated at the end of the lease, March 31st, they just leave. Your client wouldn't have claim for any rent thereafter. Because they wouldn't be holding over. The lease terminates of its own accord.
Correct, Your Honor. Yeah, I understand. I'm
All
following.
right. So with Ms. Dari, why doesn't her interest just terminate?
So, our position would be that the lease holds everyone jointly and severally liable, and the lease also addresses the holdover period.
Right, but if there are three tenants and one moves out, they're gone. There's no lease. They just leave. You're saying she's liable for the other two staying?
Jointly and severally, we believe so.
Oh, I understand what the lease says,
Yep.
but she's gone.
So, Your Honor, what we're trying to prevent, or what this could also be, is, and we don't know because parties were represented by a realtor, and my client never met these parties because of the realtor involvement. But we would not. What would happen if she applied just to approve them to move in and then never moved in? What if she was a straw person using credit or income to prove their viability as tenants and then didn't move in?
Okay, what if she did?
That's why we are trying. If we had known that, we would have used a guarantor agreement rather than having her listed on.
I get that, counsel, that things might have been done differently. But the status once she signed is that of a tenant. Whether she moves in or not, let's say she had moved in for a month and then she said, I gotta go for whatever her reasons are, I gotta go. But the tenancy is still paid for through the end of the lease. But she's not there. She basically has vacated. She's terminated her interest March 31st. Why is she liable for anything in terms of residency afterwards?
We have her listed on the lease as a resident and we're not notified or we did not know she moved out. I mean, she never said, I never moved in. You would assume that she would have mentioned, I didn't move in at some point. But during the entire tenancy, she was corresponding in the group chat as if she were one of the tenants.
Okay, but now she's gone. Let's assume that she was there even, okay? I know she's not. Let's assume that she was there. Come March 31st, she packs her stuff up, she vacates. Why is she liable for any additional rent? She's turned over possession.
Turned over possession to the other two tenants or to us? Possession was never returned.
She is surrendered because she's left.
She never notified us of a mailing address, or how is the landlord supposed to know that
Is she required to do that?
Michigan leases require notification of a forwarding address for purposes of the security.
If there's going to be an issue regarding security deposit, certainly.
Yeah, correct.
That doesn't trigger the forwarding address doesn't trigger anything.
So, Your Honor, the holdover provision of the lease would address holding over, and the jointly and severally liable portion of the lease would also state that the parties were jointly and severally liable for that holdover period. It would continue.
Your Honor, may I ask, make a statement? Again, this is not my forte, as green as possible. This is just me doing my research. So I pulled up and you can correct me if I'm wrong because I don't know this. It says Michigan law on joint and several liability. Under Michigan law, joint and several liability does not extend beyond the period for which I was contractually obligated. Any actions taken by the other tenants after the lease term ended could not be legally attributed to me. The Dracos family have solely decided without my knowledge or consent and continue to live there past the contracted date. Michigan law supports that the tenant cannot be held liable for actions of other tenants once the lease obligations have been fulfilled.
I don't know
And
what you're
that's me
reading
reading.
from, but I don't know what you're reading from, but that's fine. That is indeed my understanding.
That's what I pulled from. Yeah. So again, I don't know. I'm representing myself as very minimal knowledge.
No, I understand. I'm just saying she contracts for a year. She fulfills, however that happened, doesn't really matter. She fulfills that her obligations for that year. Contract ends. She's not in the premises, which was what the subject matter of the contract is. There are people that may be in the premises. That's fine. But I don't know how her obligation continues.
If her obligation were to end, Your Honor, she would then still be liable for March rent. So we would ask for the judgment for
March rent may be an issue if it goes through March. If March wasn't paid, certainly.
So for
I don't think in anything, and Ms. Dari, you can correct me if I'm wrong. I don't think in anything she has said, she's doesn't hold some liability for the lease term. And she believed that it was all paid through the lease term, but if it's not, she's liable for that. I don't have a problem with that. It's the period in time after the lease ends, because at that point, she's no longer occupying the premises. She never did, but certainly after the lease term, she's no longer occupying the premises.
Respectfully, Your Honor, may I ask, what was the total amount? And I can pull up the contract because again, I was informed by Sophia that they're up to date on everything. The actual lease agreement and I can pull it up right now. She's a realtor she noted, like when I got served, I communicated with her. I'm like, hey, what's going on? Yeah. So there was what is the deposit? How much was the deposit total?
the security deposit?
Security deposit, which I'm sure it wasn't sent back to them. There's still a hold.
Yep, we have 5,700.
And how much was rent total?
3,800.
3,800. So
hold on a second. Stop.
Okay.
Everybody just stop for a minute. Counsel, you're telling me that there's a $5,700 security deposit, right? There's 3,800 owing in rent.
No, there's the monthly rental payment was 3,800. We have rent owing at
1 month.
no,
so
folks. There's two different.
We have an alarm going off, so I'm gonna have to stop this proceeding. I'll come back at some point. I'm sure you can hear it probably. Court stands in recess.
District Court, Washtenaw County, State of Michigan is now in session. All those having business before the court draw near. The Honorable Judge Dixon presiding.
And good morning. Court does call the case of Jacob Properties Management versus Justin Reeves.
Justin Reeves here. Good morning, Justin Reeves here.
I got you, Mr. Reeves. We got the attorney. Counsel, state your appearance.
Jay McCurgy appearing on behalf of the complainant.
All right, thank you. What's the plaintiff's claim in this case?
Your Honor, we have rent in arrears for 1,700, late fees of 1,300.
13.
Correct, Your Honor.
So I have rental arrearage of 1,700, late fees of 1,300.
That's what we have, Your Honor.
Okay, before I say anything to Mr. Reeves, where's the 1,300 coming from?
$50 late fee, 26 days.
Pardon?
$50 late fee for 26 days.
It's $50 a day?
That's what the contract states.
Yeah, that's illegal.
Oh,
Just on first blush.
Hmm.
Well,
Okay.
let's just deal with the rent. How
Okay.
about that? Mr. Reeves?
Yes, sir.
How are you intending on paying the rent? I'm talking about the 1,700. I'll deal with the late fees in a minute.
I am saving my money, and I have reached out to Hawk and did a SER application. But I
You
am
did an SER?
working.
When did you do an SER?
Maybe 3 or 4 days ago.
Okay. All right. So you're entitled to a stay because of that, but you got to get the paperwork into us. Can you see your screen?
Can I see what screen?
Well, the screen that you're on right now, you're on a phone, right?
Correct.
Okay. If you keep swiping across, you're going to come across a QR code. That will take you to a form that you need to fill out and get to the court before Wednesday morning.
The one that says submit to 14A1.
Yeah, it's a form for rental assistance. I've got to have that form. I'm going to grant you the stay at this point because you filed for an SER.
Thank you.
Okay.
Yes, sir.
In the interim, is there any funds that you can pay?
Yeah, I can give them at least 500 today.
500? Okay,
sir.
why don't you do this? Pay 500 to the landlord today. All right. Get that
Okay.
form into us. Try to do that right away, okay?
Yes, sir.
Now, thank you for this being my first case, and let's have to deal with these late fees. But those late fees, counsel, here's what I'm going to do. You need to take a look at the case law. If the contract calls for a $50 late fee without getting into the weeds on it all and the details, a late fee can't be a penalty. That sounds to me on first blush as though it's a penalty. Also, late fees have to be related to the cost of collection, and can't be liquidated damages. So I'll leave that there and let you look at it yourself, or
thank you, Your Honor.
or I'll do it for you at some point. So
we will strike those late fees, Your Honor. I did just see what you were talking about, so we'll adjust that out.
All right.
And Mr. Reeves,
So I'm sorry.
oh, if Mr. Reeves contacts my office, we can just, I haven't heard from him, so we can just
So we'll adjourn this out. He's going to get 500 into the landlord today toward the 1,700. How much is your monthly rent, Mr. Reeves?
1,700.
17?
Yes, sir.
All right. So the problem's going to be that as of tomorrow, we're going to click in another 1,700. So we got to try to figure this out. All right.
Yes, sir.
Okay. So I will adjourn this matter. We don't have next week. Well, he gets 2 weeks out. So
June 14th.
I'll adjourn this to June 14th, 2024, 1 p.m.
Thank you.
All right. Thank you, sir.
thank you, Your Honor.
Thank you. Court calls case Victor, is it Lacka versus Michael Conlon.
Michael Conlon here, sir.
Good morning, Your Honor. Kristen Davis appearing on behalf of plaintiff.
Okay, this is a termination case.
That's correct.
All right. And Mr. Conlon, what do you have to say about this case?
Well, sir, did you receive the two documents I sent to the court on Tuesday?
I have a document in big letters requesting a jury trial,
Yes.
and then a first request for adjournment.
Yes, those are the documents.
Okay. And so, counsel, have you received these?
No, I have not, Your Honor.
Okay. Mr. Conlon, did you send these to counsel?
No, I'm not an attorney. I did not realize I had to do that. So I just sent them
Okay.
to, yeah.
So that you know, anything you send to the court, you have to send to the other side so that everybody can see what's being sent.
Yes, sir. I'll keep that in mind. I hope to retain an attorney, so they'll know that.
All right. So you're looking to get an attorney on this case?
Yes, sir.
All right. So what I will do is I'll adjourn this matter out. My next date, counsel, is the 14th. So I'll adjourn it out to June 14th, 2024 at 1 p.m. Okay. And then we'll proceed from there. But sir, you got to make sure to get this over to the plaintiff's attorney.
Okay, I'll do that. Thank you.
All right. Okay. Thank you, folks.
Thank you.
Court calls the case of Torrey LLC versus Ashley Sawyer.
Good morning, Your Honor. For the record, Neil Chanis, appearing on behalf of the plaintiff.
Ashley Sawyer. Don't have them checked in. You paid the second mailing.
I did, Your
Would you
Honor.
like to proceed with the default?
I would, Your Honor. I move for a default.
Raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, sir.
Your Honor, we're asking for a possession judgment only. By default, we show rent and arrears in the amount of $1,450, costs including statutory attorney fees of $175, for a total possession judgment in the amount of $1,625, with the writ to issue after June 10th if that amount remains unpaid.
Judgment to the plaintiff. That is by default. For possession,
I will-
redemption amount is in the amount requested with the writ to issue in 10 days.
Thank you. I will
All right.
submit. Thank you.
Thank you. Court does call the case of Group 5 Management versus Olivia Bell.
Good morning, Your Honor. Robert Weiss appearing on behalf of Group 5.
Good morning.
And Ms. Bell.
Yes, Olivia Bell.
Hello. Okay. How much is plaintiff claiming is owing? Claims is owing.
As of today's date, including the court costs, Your Honor, $959.
And ma'am, what do you have to say about that?
I want to know what the 900 and whatever he said is for.
$227 is court costs and the late fee of $75, and the balance is rent.
Rent.
Rent, $154.
I do not owe any rent. None.
Well, we're showing a balance owing of $41 from January and $154 from February, March, April, and May.
Your Honor, February of this year, I gave them $2,100. I was clear of all of that. Where this money is coming from?
Hold it, Ms. Bell. Hold on. When did you say you gave them the 2,100?
February of this year.
Okay, Mr. Weiss, hold on. Ms. Bell?
Yes.
Hold on, just hold on. Mr. Weiss, do you see the $2,100 payment?
Well, Your Honor, we had switched operating systems, so the ledger I have does not show $2,100. I can go back with my client and get a ledger from the old system and see if it's there.
Okay. All right, Ms. Bell,
Yes,
what's
sir.
your monthly rent?
154 now. It went all the way back down because they
Okay.
were charging me 297.
Okay, but you're at 154 now?
Which is
Yes,
what,
sir.
which is what we're showing, Your Honor, from February, March, April, and May, $154 owing, plus a balance from January of $41.
Right. But she's saying that 2,100 was given, so we gotta figure that out.
Okay.
So Ms. Bell, so we're gonna click into June. When can you get the 154 in? Because I'm gonna adjourn it out for them to take a look to figure out where this other money is.
I just paid my 154 day before yesterday.
Say that again to me.
I just paid 154. No, I paid 159 just day before yesterday.
We're not
And
showing.
that was for your June rent?
My June rent.
Okay, so you paid that, you said day before yesterday, so you paid that on the 29th?
Yes, sir.
All right, let me just note that in the file.